What if I told you that some of the most liberal judges in America just handed down one of the most surprising decisions imaginable, a ruling that suddenly makes President Trump's push to end birthright citizenship more conceivable than ever? What if I told you that this decision handed the Trump administration legal ammunition that could fundamentally reshape how the 14th Amendment is interpreted? Stay with me to the end of this video, because this court opinion may change everything we thought we knew about who qualifies as an American at birth. Hi gang, it's me, Dr. Steve, your patron professor, here to help you cut through the noise as the far left scrambles to stop a conservative resurgence you're helping make possible. If you want a front row seat to how you're changing the world, hit subscribe and smash that bell. Here's the case everyone's talking about. A man named Roberto Monata was born in New York City in July 1950. His father was a Nicaraguan national assigned to Nicaragua's permanent mission to the United Nations. For nearly 70 years, Monata lived and worked in the United States, assuming, as did the government, that he was an American citizen. The U.S. issued him passports over the decades without question. Then, during a passport renewal in 2018, bureaucrats dug deeper and realized Monata's father wasn't a consul, as had long been believed. He was actually an attaché with diplomatic immunity. That distinction matters enormously under the law. Children of consuls can claim U.S. citizenship at birth. Children of attachés with diplomatic immunity cannot, because diplomats with immunity are not considered subject to the jurisdiction of the United States for purposes of the 14th Amendment. In other words, diplomatic immunity places those individuals outside the political jurisdiction of the U.S. So, overnight, a man who thought and had been treated as a U.S. citizen found his status reversed. The government concluded he had never been a citizen at birth. Monata sued to keep his citizenship, and his case wound up before the Ninth Circuit Court of Appeals, the so-called Ninth Circus, widely regarded as the country's most liberal federal appellate court. The Ninth Circuit ruled that Monata was not a U.S. citizen at birth because his father enjoyed diplomatic immunity when he was born. The court held that Monata did not meet the constitutional prerequisite for automatic conferral of citizenship under the 14th Amendment. Now, legal analysts are watching closely because the phrase that decides this case is the amendment's qualifying clause, and subject to the jurisdiction thereof. That clause is the linchpin. The simple fact is the 14th Amendment grants citizenship to all persons born or naturalized in the United States and subject to the jurisdiction thereof. The controversy has always been whether being born on U.S. soil alone is enough. The Ninth Circuit affirmed what most legal scholars have long recognized. Being born here is necessary, but not sufficient. You must also be subject to U.S. political jurisdiction at birth. That matters because historical context and earlier statutes draw a line between territorial jurisdiction, the obligation to obey local laws while physically present, and political jurisdiction, the allegiance and legal authority that makes someone a political member of the United States. Tourists and temporary visitors obey American laws while here. That obedience does not make them U.S. citizens. Diplomatic personnel with immunity remain under the political jurisdiction of their home countries. Their children are excluded from automatic birthright citizenship. The Ninth Circuit reiterated that clear, narrow rule. What has conservatives excited and liberals worried is what this ruling implies beyond diplomats. If the court insists both conditions must be met, then the broader doctrine of automatic birthright citizenship for every person born on American soil could be vulnerable to reinterpretation. The argument President Trump and his supporters advance is straightforward. The framers and the historical record intended, subject to the jurisdiction, to exclude those who retain political allegiance to foreign powers. If that reading prevails, it opens the door to efforts, executive orders, statutes, or ultimately Supreme Court review, aimed at narrowing birthright citizenship more broadly. Critics will say this is panic over a narrow decision about diplomats. They'll point to decades of precedent and the common understanding that the 14th Amendment created near-universal jus soli citizenship. But supporters of change note that some of that understanding rests on a single footnote in a 1982 Supreme Court opinion, and they argue the legal scaffolding for universal birthright citizenship is shakier than people think. The Ninth Circuit's decision may be limited to its facts, but it provides a persuasive, conservative-friendly doctrinal hook. Citizenship requires both birthplace and subjection to U.S. political jurisdiction. So, what happens next? Expect legal challenges, appeals, and likely a battle that could end up before the Supreme Court. If the High Court accepts a similar case and adopts the Ninth Circuit's reasoning more broadly, the consequences would be enormous, potentially altering who can claim American citizenship simply by being born on U.S. soil. That's why this one decision, from what many consider the nation's most liberal circuit, has conservatives cheering and liberals alarmed. Before we keep going into the constitutional weeds, quick note, there's another kind of battle you should know about, and it's happening inside your gut. The war between good and bad bacteria determines much of your health. That's why I take Kimchi 1 from Bright Core Nutrition every morning. It's a fermented superfood packed with hundreds of beneficial strains that support digestion, immunity, and even healthy weight management. It's natural, non-GMO, dairy-free, gluten-free, and made in the USA. Use code TURLEY for 25% off or call Brightcore for bigger savings. It's made a real difference for me. Back to the main point. The Ninth Circuit's decision confirms a crucial principle. Not all births on U.S. soil confer automatic citizenship. If one liberal appellate court can say it plainly about diplomats, then the constitutional debate over birthright citizenship, precisely what subject to the jurisdiction means, is very much alive. Whether you see this as restoring constitutional fidelity or as the opening salvo in a campaign to strip rights from children born here, the legal landscape has shifted. Stay tuned and keep paying attention. This could be the start of the most consequential immigration debate in generations. Have you locked in your seat for my America Awakens Masterclass yet? Seats are filling fast. Click the link, claim your spot, and join the rising tide of Americans reclaiming faith, family, and freedom.